just raise your hand and speak up.
Yep,
Happy to answer questions. I have about an hour today to spend with you guys. I hope that's okay.
that's great.
Um, but I'm delighted to. So thank you so much. Can you hear me okay?
Yes, we hear you great.
Great. Well, thank you so much for the uh, invitation to participate in your seminar series. I hold your institution in great regard. So, some of the best papers, I think, in the whole privacy field have come out of CMU over the decades. And I'm proud to know a lot of your faculty, current and past. So in this talk, I'm going to try to convince you of three things. First, that technology has certain characteristics which tend to interfere with sensible legal analysis and intervention. Second, that the best antidote for this tendency of technology to daunt and confuse law is approaching law and technology more methodically. And third, that methodology, more so than a common subject matter, is actually what makes or could make law and technology its own field. Okay? So technology has certain characteristics. So technology is a social fact like any other, but it has proven very difficult for law, which incidentally is among society's best tools for pushing back against technology, for channeling it in the public interest. But it's proven very difficult for law to analyze. And I think that's related to primarily three things. First, technology poses as inevitable when in fact it's contingent. So I mean this in two ways. First, overall, American society tends to accept technological change as inevitable and conceives of the role of law as responding to the resulting disruption. Technology's changed everything. What's the law going to do about it? How are we going to restore the status quo ex ante? How are we going to respond to this disruption? When I teach undergrads tech law and policy, which I do through the information school in the spring, I assign them a reading about how the Amish decide what technology to use or not. Because the Amish don't say, oh, I guess now there's augmented reality. We're all going to try it out. Let's see how it works for Amish society. Absolutely not, right? They will not invite technology into their community unless they feel ex ante like it is consistent with their values. And they will often adopt a version of a technology that is not contemporary because it better suits their values. And so I'm not trying to say we need to be like the Amish, but it's a good way to remind yourself that the our reflexive acceptance of technology is not universal. Okay. Second, the second way that I mean that it poses as inevitable when it's contingent. Law professors and especially policymakers tend to think of their object of analysis as whatever instantiation of emerging technology is placed before them. I testified before the United States Senate years ago about drones in law enforcement. Not only did the drone industry demo a drone for the senators prior to the hearing in Senate Commerce, but throughout the entire hearing, they took a quadricopter that could stay up in the air for 15 minutes, that looked pretty innocuous, that had two cameras on it, and they left it on the table for the duration of the hearing so that the object of the hearing was that instantiation of this technology. And my point at the testimony and subsequently has been, what are we worried about with drones? We're worried about mobile aerial surveillance. We're worried about the ease with which you can surveil people over time or a crowd of protesters, maybe even met out violence through these objects. We're not worried about this particular quadricopter. We're worried about the affordances of robotic surveillance And so I encouraged the senators. Ultimately, no bill was ever passed, although Senator Leahy out of Oregon heeded my advice. I encourage them to talk in terms of mobile aerial surveillance rather than these particular drones. And this happens over and over again. So it happened in the state of Nevada where they passed a pioneering driverless car law that was based entirely on Google's entire driverless car, and then a year later had to repeal the law when other car makers came in and said, this seems to affect my car too, but it's not driverless. And so um, it's happened with robotic delivery where a dozen states have laws saying, yeah, you can use a robot to deliver things on a sidewalk as long as it has these exact parameters. And the exact parameters are what the leading robotics manufacturer of these carts, Starfleet, what they propose to the legislature. So we take technological change as inevitable, and we tend to focus on whatever the market coughs up as if that were the only possible morphology for the technology that we see. Okay. The second thing that makes legal analysis challenging is that technology tends to make a shell game of responsibility. I'm sure many of you know what I mean by a shell game, but it's like when the cup's in the ball and you're moving it around and you don't know which cup the ball's going to end up in. As we understand very well from the likes of Langdon Winter and Bruno Latour and others in STS, Science Technology Studies, whenever technology is being used and and there's a harm or an accident, there are decisions and will and ideas that are present that don't feel like they are. Whenever you do something with or through technology, you're carrying with you the politics, the assumptions, the decisions that happened that went into the design of the technology, even though it doesn't feel like those people are present, they are. And so one example of that is the driverless car fatality from Uber in Arizona. In Arizona, a driverless car was all day long driving around in Arizona. Got towards the evening, there was a woman that Uber had hired to sit behind this driverless car and essentially like monitor it, but it was driving itself the whole time. Someone else, a pedestrian, crossed in front of the Uber car against not in the crosswalk. If a human driver had been driving, they easily would have seen this woman. She was actually pushing a cart. It was not hard. Um, and yet the Uber vehicle did not detect it, and the driver was not paying attention. We see video of her from the interior of the Uber suddenly looking up and realizing that she needed to intervene, and it's too late. So this woman died, and the driver of the Uber vehicle, which I put in quotes since she was hired to not drive, um, was charged criminally for negligent homicide, basically you know basically not paying attention so someone died. Criminally, she's charged. And Uber settled out of court, but there was a Department of Transportation investigation of Uber and its team that built the driverless car. And this DOT report said that there was a lax safety culture at Uber at this particular moment. And among the things that Uber did was this was a Volvo that they were adapting to driverless cars. These Volvos have automatic collision detection built into them so that they actually will detect and stop if there's an obstacle in the road that the driver doesn't see. Uber decided to turn that off, according to this DOT report, so that they could test their own collision avoidance mechanisms, which failed. So that's one of the things that DOT pointed out as being problematic from a safety perspective. Why not have that redundancy? Now, unlike the driver that they hired, who was expected to sit in something that drives itself all day long, and then the one moment when something goes wrong, to suddenly be alert in the moment and respond in an emergency. The decision to turn off Volvo's own safety features was done in the light of day. Someone in their office, a group of people talking about it for as long as they want in a conference room. And yet that decision is not visible, right? And there are countless ways in which technology introduces decisions and introduces agency, will, politics, assumptions into these environments. That is indeed the lesson, long lesson of STS. Okay. And the third thing that makes technology difficult is that technology appears impracticable or imprudent to regulate. So one of the best ways I've heard this articulated is very old. It's David Collingridge's The Social Control of Technology from 1980. I highly recommend this book to you, and I cite it extensively in my own work. And Collingridge presents something that has become known as the Collingridge dilemma. He didn't call it that, but people have called it that. And he's talking about the problems that policymakers encounter when they try to regulate technology. And you may have heard of a version of this that's called the pacing problem. If you go to a cocktail party or you go to a dinner party and you sit next to somebody and you say that you do law and technology, invariably that person will say, oh, well, that's hard, right? Because law is so slow and technology is so fast. The pacing problem. So that's a version of this, but the original full articulation is worth discussing. Collingridge argues that policymakers who want to intervene in technology face a double bind. The first bind is information. It's the idea that you don't know what technology is going to do in society. You don't know what the harms are going to be. You don't know what the benefits are going to be. You don't know how people will use it or won't use it. And so regulators can't wisely intervene, they think, because how would you know if your intervention is justified or warranted, or a different one would be better? But then if you just kind of let technology play out like we do in American society and wait for the harms and the benefits and whatever they are to accrue, wait till the data center is keeping people up at night and not so that they don't and taking away their water so that they don't have water to shower, or they pay astronomical amounts for electricity. Wait until sycophantic artificial intelligence chatbots help kids commit self-harm. Wait until these things happen, and only then will you intervene. Well, then he says you face a second bind, and the second bind is power. The idea being that once you go to regulate something with adequate information, that technology has become path dependent. People rely upon it. And oftentimes the people that are in the technology industry have made so much money that they can afford to hire lobbyists and lawyers and everybody else. And then it becomes really hard to intervene. And we see that with ChatGPT. ChatGPT became immensely popular. People don't feel like they can live without it. OpenAI has become a major technology player. And now Sam Altman can go to Europe and say, if you overregulate us, we won't make our products available to you. And Europeans will be genuinely distressed about that. We see it with Airbnb. We see it with Uber. It's so common in technology circles that people have argued that technology can be a form of regulatory arbitrage, where you just do something that everybody's been doing all along, like rent hotel rooms or give people rides in a taxi. You call it technology, and you ward off the same rules that apply to your competitors long enough to entrench yourself in the market. And then once you do that, you blast all your users saying, oh, they want to regulate us out of Austin. In other words, you gain a foothold in the market by not playing by everyone else's rules because you're technology. And this is a phenomenon that is studied. Elizabeth Pullman has papers on this, for example. Okay, so those are the things that make it hard. What do we do about it? Well, I'm not going to sit here and describe my methodology in painstaking detail. There's a whole book about it. It has 4 steps. Each step draws deeply from other disciplines such as science and technology studies, the philosophy of technology, affordance theory out of perceptual psychology, and so on, value sensitive design, envisioning and forecasting. But the point of the methodology is to step by step, as you analyze technology, you do so in a methodical way with a bunch of prompts and some sub prompts, meaning questions and tasks that are designed to help overcome these tendencies. So, for example, the methodology requires you to define the technology at the appropriate level that you want to analyze with it. Sometimes this is called, the unit of analysis. Are you looking at robotics overall? Are you looking at drones? Are you looking at, autonomous robots, whatever, social robots? But it requires you to do the work of explaining your unit of analysis for eventually for law and policy, so as to avoid some of these problems around inevitability and contingency. It requires you to really do the work of imagining possible future scenarios so that you can work on guardrails even in the absence of perfect information, which incidentally is also something that Collingridge, in the second half of his book, argues that you should do. It talks about what your normative baseline is. So it gets you to ask your question, like in law, we love to tell people what to do. Like there's no discipline outside of moral philosophy that's more comfortable saying should than lawyers. In fact, it is an expectation. If you write a paper that describes the law and at the end you don't tell people how to reform it, they go, this is not normative, or where's the normative part of this? Where's the should? And so if you're telling people what they ought to do, if you're telling society that they should change law, which incidentally has a monopoly on the justified use of violence. I mean, when you violate the law, the state can come in and interfere with your life in a significant way and claims justification for that. So when you propose legal reform or you tell people what they ought to do about law and technology, you need to have a reason behind your should, a normative baseline. Are you trying to restore the status quo ex ante? Are you trying to maximize benefits and minimize costs in a kind of roughly utilitarian way? Are you anti-racist? What is your where is your should? And then finally, the methodology asks you to describe the full range of potential interventions. One of the things that's always frustrated me in debates with people who are against the precautionary principle. So the precautionary principle says you shouldn't interfere with technology up front because that kind of precaution will cost lives because people will not benefit from contact tracing apps or genetically modified organisms or nuclear power, whatever it is. And they say you can't, stop this stuff in advance because we'll never know the full benefits of it. Oftentimes in those debates where the preference is what Adam Thier calls permissionless innovation, just innovate without permission and see what happens, is that they're not sophisticated about the full range of interventions that might be possible. One of the things that they overlook, for example, in the United States is federalism. The idea that just because you ban something in one place or you regulate it in one place, like Pittsburgh, doesn't mean that it needs to be regulated in Seattle. Unless you're doing a national ban across all of the United States, which is vanishingly rare. I mean, there was a brief time when we would not commit any federal funding to stem cell research under the Bush administration, but there's been very, very few things that have ever been banned at a national level, including research into avian flu, which is really, dangerous potentially. but you have a federated system. And so people like Margot Kaminsky at Colorado argue if you want to figure out what to do about drones, don't have the Federal Aviation Administration govern these technologies, have the states decide. And each state can make their own decision. You also have things like sunset provisions, which say this will be in effect for a certain amount of time and then sunset, and we'll have to make another rule. You have things like regulatory sandboxes where you create innovation zones. And then you have everything from, you know, rules to standards. One of the things that frustrates me about the claim that, oh, law is too slow, it can't keep up with technology, is a lot of the tools that enforcement has, like the Federal Trade Commission, are pretty resistant to they're future proof because the Federal Trade Commission is supposed to police against unfair and deceptive practice. So unfair and deceptive practice is a standard, and it doesn't make a lot of sense to say that the law of unfair and deceptive practice can't keep up with technology. Because, of course, as technology changes, you can discover what is unfair or deceptive. Um, so, yeah, there are times when there are outdated laws. I've argued recently that the Computer Fraud and Abuse Act, after many, many years since the 1980s, is no longer a valid way to think about cybersecurity and hacking. Um, it just doesn't account for machine learning. It held up for a while. It had a pretty amorphous standard, which was unauthorized access or access exceeding authorization. Worked really well for a while with some problems. But today it's no longer valid. But a lot of the tools that we have are not like that. Okay. So to sum up, technology has these characteristics that make it difficult for policymakers and legal minds of all kind to grapple with it. Okay. I've described what they are, that it poses as inevitable when it's contingent. It makes a shell game of human responsibility, and it appears impracticable or imprudent to regulate. The best antidote to that is a methodological approach, one that is not presently on offer, at least in an express way. But I will tell you that in writing this book and coming up with a methodology for analyzing emerging technology, I drew heavily from what the community was already doing. So I'm mostly formalizing things that law and technology scholars do anyway without saying that. And one of the reasons that I do that is because I think law and technology deserves to be its own field. And I think the best way to unify law and technology as a field is to lay out what we do as a methodology. Now, in theory, you could imagine law and technology being unified as a field the way that animal law is unified, or health law is unified, or environmental law is unified, where the idea is it's the subject matter, right? Animal law has a common subject matter, health law has a common subject matter. So in theory, you could say, well, law and technology is like that. That's what unifies it. It's like it's the subject matter. And there's two problems with that. The first problem is that no area of law is actually only unified by common subject matter. Animal law is not just about animals. It's not just like any time the law talks about animals. That doesn't make any sense. Okay. It's not like every time you have a contract among horse breeders that goes awry, that's animal law. Okay. Animal law is unified by a common commitment to animal welfare. The debates within animal law are about welfare versus rights and, how much to cede to non-human animals versus human animals, intersections with environment. They all go to the same conferences. I've been to the conferences to sort of see what they're like, and I'll tell you, now all the food is vegan. Nobody's wearing leather. Okay? These folks are united by common texts, communities, and a common goals. And the same is true of environmental law, and the same is true of health. And so it's not just that anybody. The second problem with using law and technology just as the subject matter, as the unifying principle, is that once upon a time when some of us, I see like Laura and Alicia in the chat, for example, some of the professors that were doing this 20 years ago, 10 years ago, there weren't that many people doing law and technology necessarily. And so, we could be the people that were studying the internet or later robots or studying augmented reality or whatever it is that we're studying. Okay. But today that's not true anymore because there is no area of law where technology doesn't matter. You cannot write about the law today unless you're writing something very theoretical, historical, but most contemporary problems involve technology at one level. So to say that I do law and technology, where I mean that I analyze technology with the law, becomes a bit silly because so are my colleagues in trust and estates. So are my colleagues in contracts. All of my colleagues are looking at technology in some way. But there's another way to unify a field, a very powerful way, and that is through methodology. And one example is law and economics. Law and economics is not like the law that studies economics. It's not like anytime there's an economic dispute or how to structure an economic system. Law and economics is a method whereby you analyze um, uh, legal issues through the lens of efficiency, through economic modeling, through incentives. It's a way of approaching all manner of law, criminal, you know, tort law, certainly, tort law, which I teach, is replete with law and economics. Another example is law and literature, where I think of people like Jessica Silby at Boston University. Like these are J.B. White, who I took classes with at Michigan. These are folks who use literary canon, literary tools, literary analysis in order to unpack legal decisions, statutes, and the like. And there are yet more um, areas, and this is where I'm going to end and open it up to questions and comments. There are areas that are unified by both subject matter and method. And that's what I think that law and technology should be. So I'm thinking, for example, of critical race theory. Critical race theory is about race. It's about race. Um, but it's a method of looking at legal institutions and decisions and structures through the lens of race and hegemony and anti-racism. And we still need critical race theory, even though, and especially because race is important everywhere. We still need law and technology, even though, and especially because technology is present everywhere. So in a world where technology touches everything, maybe doing law and technology means approaching the social fact of technology in a methodological way, in a methodical way. And that's why my method is meant to capture what people in the field already do and formalize it and make it legible to new entrants and defend it, in essence. Now, there are other insights in the book. For example, I talk a lot about science and technology studies and why every person in law and technology should be aware of it, but that it would be a mistake to simply turn law and technology into STS, a branch of STS, because of STS's differing commitments. At the end of the book, I give advice about how I would like to see law and technology change, both at the ecosystem level, like how do we do better technology governance overall, but then also in terms of the practice, I argue that we should do more tech assessment and less trying to restore the status quo. But the gist of the book are the things that I just described. And so I said I would try to convince you of these three things. If I succeed, great. And if not, then you should buy the book and tell me exactly how I'm wrong. Anyway, thank you so much for the opportunity to address you, and I'm happy to answer any questions that you might have.
Yeah, so I think with questions, you're welcome to just type them in the chat, or I think the room mic is on, so you're also able to just raise your hand and
Sure. And do speak up because I'm having a little trouble hearing you.
Oh, okay.
Of course, I know this is a privacy seminar. I am a privacy scholar. I write about privacy harm. I write about information asymmetry and the way that companies can take advantage of you based on what they know and the ability to design your environment. Um, More recently, I wrote about with a colleague, Maria Angel, about what defines privacy as a field as opposed to any kind of information-based harm. And I got into a big fight with Dan Solov about it. We're still going back and forth about it, Dan and I, and Maria. So, any questions you want to ask a law professor who does technology law, privacy law? This is your chance.
Okay, I'll shoot. So the proposal is to do something about emerging technologies without actually knowing what the risks and benefits are of those technologies. What is your methodology for dealing with that?
Yeah. Um, so first of all, I think that it is unlikely that we would know nothing about the technology. So what the methodology does is it tries to unpack what distinguishes the technology under analysis from previous and constituent technologies. What is different with augmented reality versus just a regular old screen like the one you see me on, or virtual reality? And then it uses affordance theory, which is a well understood and widely sort of circulated, uh, although based in the work of James Gibson and perceptual psychology, to ask how does this technology change human affordances? What can we do now we couldn't before? What is easier? What is harder? And then it uses that that set of insights of definition, envisioning, and so on to come up with plausible outcomes, and then to say, well, in this case, we want this good thing, and we're going to use our tools to incentivize it. And in this case, we are worried about this potential bad thing, and we're going to make it so that that bad thing is less likely to happen. If truly we had no idea what technology would do at all, or any other social fact, any other development, um, then yes, it would be a recipe for paralysis. I mean, we would never intervene any time ever. Um, but I just don't think that that's true. I think that there are any number of, I mean, if you look at scenario planning and you look at envisioning and forecasting, companies like Shell Oil used it in order to navigate various energy crises. The British government uses it. It was developed at a very serious place, RAND, and it is a quite a structured and defensible way of trying to figure out not what's going to happen for sure. We always can be surprised, and we have to be able to pivot. But having some sense of what's going to happen is realistic to me. Even if you don't believe that, then the methodology lays out options for a situation where there's great uncertainty, which involve federalism, regulatory sandboxing, sunset provisions, tools that the law has to deal with areas where there is deep uncertainty so that we can see how it plays out in a more bounded way without letting it spread throughout all of society, and use that as a kind of a petri dish to see what the harms may be, and then base our regulatory structures on that. There's a lot of exciting work being done in the United States and Europe on, for example, regulatory sandboxing. So I just have always felt it was a false dichotomy. And while I appreciate the Coleridge dilemma, you know, Coleridge spends the rest of his book talking about how society can get out of that dilemma. And I spend a lot of my book talking about how law and technology can get out of that dilemma.
Well, let's take the example you brought up, which is ChatGPT counseling suicide, for example. How would we anticipate that it would do that? And what kind of precaution could we take in regulating LLMs that would prevent that?
So, um, for any number of the harms that you read about in the New York Times, like people killing themselves interacting with ChatGPT, I promise you that there were people bef- way up front that were envisioning that that could happen. Um, you know, I myself have told, companies, this seems concerning. Have you thought about this? Right? Um, Joseph Weizenbaum, when he designed Eliza in the 60s, said, I'm really worried about the mental health of people that are interacting with this Rogerian, like simple Rogerian chatbot that I made up, right? These things were predictable, and it was more expedient for OpenAI and so on to um, release them, notwithstanding their syncophacy, and then not have adequate protocols in place to guard against what was happening. How do we know they could do it? Because they did do it. But the idea that nobody thought, I mean, even when Microsoft released Tay onto the internet, people said, I don't think you should release a chatbot onto the internet that learns from internet trolls because it's going to become really vitriolic. People predicted that. That's literally what happened. They had to shut it down. So, I think there's a real denial going on that people are aware in advance, and it's truly that the mindset of technology companies in the United States is they want utility, they want adoption. Another example is I'm involved in a lawsuit against Apple over AirTags, um, and also Tile over their version of it, because Apple was told if you make something that can track people surreptitiously using their phone or using this little easy to install AirTag, it's going to be used for domestic violence, like for sure. Like people are going to definitely do that. And Apple was like, okay, well, we'll make certain interventions and whatever. And then they released the product, and dozens of people have died or been terrorized by domestic abusers using Apple's tools. And this is like we have a bunch of named plaintiffs in the case who was the case. So again, it's just to say that the notion that we cannot have any sense of what the harms are going to be of this technology in advance, it's both factually inaccurate, in my opinion, and then second of all, a recipe for paralysis. So what could ChatGPT have done better? They could have done better red teaming. They could have had better protocols. They could have done what they're doing now with additional child safety precautions up front at the beginning because it was so predictable, but they didn't. And look, I teach tort law for a living, and one of the important things in tort law is foreseeability. You really are not going to get in trouble in tort law under negligence unless the category of harm that occurred was foreseeable. All this stuff would qualify as foreseeable, in my opinion, under a negligence proximate causation inquiry. So, sorry, I know I'm belaboring a little bit, but I do think this is a really important point. If it turns out we really can't know what technology does until it does it, and that guardrails are senseless, well, then we're in this Hobson's choice between we're not going to allow it at all, or we're going to let it do all these harms first. But I don't think that's true. I don't think that's true.
Yeah, sure. So I think I saw a hand raised first. Bryce, if you want to go ahead.
Hey, pleasure to speak with you today. And first, before I jump into my question, really appreciate your work on privacy harms. And so thank you for your contributions. And it's cool to get to see you, here virtually. It occurred to me that many of the folks that are listening to you are going to find themselves working in industry. And the scale of everything that, kind of happens in, some of these large companies, has the potential to be overwhelming. And so while there are many frameworks in this space already, your kind of suggestion of methodical approaches is it's very pragmatic. And so I'm curious, like, what's your view on what companies should be doing today that they're not doing in their own, methodical approaches? And like you were just speaking kind of about specific guardrails that were missed, but like in your view, what inherent governance structures do private organizations, not have, or which ones fail the most that kind of, would have otherwise had the promise to prevent some of these harms?
Yeah, I mean that's a great question. So my book is primarily directed at people in the legal and policy field or people who are very curious about the law and policy field. I do think it has utility for a company trying to figure out what to do about emerging technology and how to figure out like what's next. In fact, I've given this talk to companies, and the feedback I got was that it was useful. Maybe they were making that up. But what I would say is that companies, I think, need to invest more heavily in red teaming and safeguards up front. And one area where I think that's starting to happen is in agentic AI. I think there's widespread understanding that if you have an agent that has the capacity to engage in emergent behavior, either alone or in dialogue with a person or dialogue with other AI agents, that prospect of emergent behavior is concerning. And so some of the major AI companies are coming up with protocols that you can take and layer on top of your AI agent in order to create certain safeguards. And it reminds me of kind of the role of custom in tort law, where what other people are doing, oftentimes the way that you show liability in tort law is you show that this company could or individual could have done it differently. Look at how they do it over there. I got hurt in your apartment because you didn't install shatterproof glass in the shower. Well, look over here. It's the custom of all of your other landlords to put the shatterproof glass in, which suggests both that it is reasonable and second of all, that it's affordable. Um, and so, I really think that companies should be doing a lot more at the outset. And as Laura points out in the chat, there's been some very decent documentation that a lot of these companies foresaw these issues and just went ahead anyway. Like employees were like, "This is going to happen," and like we see that all the time. Another example that's from the past is, nuclear power. In the early days of nuclear power, everybody, anybody paying any attention raised their hands. Like the problem with nuclear power is that it's not just that it's a safety issue, but it's gonna make this material that's gonna, be really toxic. And we got to figure out like a plan before we start opening these plants and what to do about the nuclear waste. And there's these funny conversations that you read, if they'd be funny if they weren't tragic, where scientists are saying things like, we split the atom. I think we can figure out what to do about a little garbage. And yet, for decades and decades, we actually made a bunch of nuclear power plants without a national plan. It was 30 years before there was ever a national plan from Congress about what to do with nuclear waste. And we're still dealing with it now. It is not because we could not anticipate that there would be nuclear waste. Gosh, I didn't realize that nuclear waste would be an issue. It's because there wasn't the political will and there was a lot of hubris. And I think that's what's going on too. I'm not one to analogize the internet or apps to tobacco or oil or nuclear power. Bless you if you want to make that analogy. That's great. That's not what I do. But I will say that I think a lot of these harms were known and people bulldozed through it anyway. And so I think if you're a company and you're going to work for a company, I think a lot more precaution is warranted than what we're seeing.
Thanks. I think we have a few more questions.
Sure.
Prahlad, if you want to shout it out.
Yeah. Hello, Professor Calo. Yeah, we've read your work from the first semester. So really impressive.
Can you speak up a tiny bit? I can't hear you.
Yeah, I'm a second year privacy engineering student, and we've been reading your work right from our first semester, and it's really impressive. So my question is like, who is the one who should be like, you said you want a framework or something. Who is the person who should be actually doing this? Because like before chat gpt itself became big and people have now started understanding it, it took almost 3 years for people to come up with what's inside and what's happening. And like who should be the one who's doing? And I don't think except some cs students, like non-cs students don't understand how actually transformers or even language models work. So
Yeah.
who should a person inside, like the developer do it, or the company do it, or a lawyer do it, or a third party entity does it?
Yeah, that's a great question. So I will answer that and this is in the book in the final chapter, um, to say that I think there's certain things we could really do better to improve our ecosystem. And I think one of the things we could do is we could do more tech assessment. Tech assessment is more the European model, but it was also the model in the United States in the 70s and 80s. We created the Office of Technology Assessment. It was a several hundred person interdisciplinary bipartisan agency that was designed to help Congress navigate technology wisely. And it was full of people that were capable of understanding the technologies of the time, both permanent people and contractors. And it was designed by government and academia working together. The Office of Technology Assessment advised Congress for 2 decades until it was defunded in the Gingrich Revolution in the 1990s. And one of the reasons it was defunded is because it urged greater precaution and it put the onus on industry to be more careful about deploying technology. And Republicans at the time did not like that. And Gingrich did not like that. And he defunded it right before the commercial internet exploded. And I always wondered to myself, what would the internet or app ecosystem or AI look like if we still had an OTA? Office of Technology, OSTP, Office of Science Technology Policy did persist and advises the White House to this day, and it waxes and wanes. So one of the things I think we need is to resuscitate the OTA. A second thing I think we need to do is protect whistleblowers and third parties who are trying to hold companies and others accountable. A lot of the times we find out about technology harms. Remember I said, technology makes a shell game of responsibility. The people that are playing that shell game well are often independent third-party researchers. It's because of independent third-party researchers that we know about, for example, the Volkswagen emissions scandal, right? And it's because of internal whistleblowers that we know that social media companies knew in advance what the harms were and persisted anyway. And so I think we need to protect. Why protect them? Because, sometimes third-party researchers face cease and desist orders under the Computer Fraud and Abuse Act. I mean, Alicia, I think, could speak to that very well. But Ed Felton, Jonathan Mayer, lots of different people, famously Aaron Schwartz. I mean, there are not adequate. There's not been an adequate, crystal clear articulation that we are protecting whistleblowers and third parties. Anyway, I have more suggestions. I don't want to go on and on and on, but I do think that like the onus has to be on the companies to be doing this work in advance, and people who are trying to hold them accountable have to be protected, maybe even elevated and funded. And government has to have adequate expertise so that it doesn't just have to take industry's word for everything. Yeah, I don't know if that's adequately responsive, but that's what I'm hoping to see. It's the last chapter of the book. I don't know if you guys have do you have access to Oxford Academic? Because if your institution has Oxford Academic, you can actually go and read the book like online. Yeah, that's true, Laura. The Amnesty International blowing the whistle on Pegasus. What's the group out of Toronto that's so excellent? The Citizen Lab in Toronto. The folks at NYU looking at political advertising on Facebook who faced a cease and desist. Ethan Zuckerman's lawsuit about a tool that helps to collect information for third parties. I mean, there's just all these battles going on around accountability and the lawfulness of accountability, and it seems to me that that's an easy way for us to improve the ecosystem.
Um, I think you mentioned you have a hard stop at 1:30.
Well, I can go a little bit later than that, but I need to travel from here to an appointment that's about 20 minutes away. So maybe I have another 10 minutes.
All right. Okay. I think we have a few more questions, so that's
Good.
great. So Michael, I don't know if you want to go next.
Okay. So it sounds like the methodology, as you were describing it, would require a certain baseline understanding of technology on part of the people who would be using it. That strikes me as something that people in government, particularly elected officials, often lack. I know you were just talking about the OTA or other potential bodies that would presumably have more technologically knowledgeable members, but in general, are there other ways that you imagine sort of compensating for working around the lack of knowledge of technology in government? Is it just voting for people who know more things about technology, or do you have anything else in mind?
Well, so I think one of the things you hear about why it's hard for lawyers to deal with technology is because technology moves too fast. Like lawmakers are slow, technology. Another thing you hear is that it's so complicated and specialized that people can't understand it. And I got to tell you, I have had any number of conversations with patent attorneys, and they just laugh at that. They go, "What? Like I have to go from knowing absolutely nothing about semiconductors to knowing so much about semiconductors that I can stand up in court and argue why my client's semiconductors are different from the ones that they're suing us." I mean, we train our lawyers to understand a context well enough to argue about it. Like that's what we do. And patent lawyers always laugh at me because they're just sort of like, I don't like if it weren't possible for lawyers to understand technology, I would not have a job. And so, I think part of it is, and another thing I get all the time too is I get students who come up to me, junior folks who come up to me and say, I really want to be in law and technology, but I'm not a technologist. I have no technology training. And I say to them, that's fine, right? One of the things that I do in my own work is when I'm writing something about technology, I simply co-author with people that know technology. So for example, I was talking about the Computer Fraud and Abuse Act and how I think it's outdated. I wrote this paper that's called Is Tricking a Robot Hacking? And it's about adversarial machine learning and the way that adversarial machine learning breaks the CFAA, basically. I didn't just wade in there on my own. I was on a team with Tadayoshi Kono, a famous security researcher, now at Georgetown, was at UW. His postdoc, who studies specifically machine learning, and one of their PhD candidates, Yvonne, who studies adversarial machine learning, myself, and a law student, David Owens, who ended up going as an in-house lawyer at Electronic Arts, the gaming company. And so we were pretty confident that we got the technology right, and we were pretty confident we got the law right in that paper because we held hands across disciplines. So there's a lot of possibilities, right? You can have expertise that you trust, in-house expertise. You can learn the technology yourself. So I just want to get away from this world where there are these wizards in Silicon Valley, and they're the only ones who understand technology, and we have to take their word for how it works. And gosh, they don't know how it works sometimes. And I just think that's a bunch of garbage. I just think that like we can figure it out. We can have expertise in government. We can have lawyers who figure things out. We can hold hands with other disciplines. I've never found it to be that challenging. And I'll tell you that you can go through my work if you want and point out all the ways that I got technology wrong. But I will tell you that everything I said about technology, and especially in the last decade, I have run by people, different people who I wrote a paper called Modeling Through in Duke Law Journal that's about how computer modeling could be used to improve policymaking overall. I ran it by my colleagues in computer science who do computer modeling to make sure I at least wasn't making shit up, right? And I just don't think it's as challenging as people think.
Thanks. Yeah, I think we kind of echo the sentiment of cross-disciplinary collaboration here at
Of course you
CNUS.
do.
So
You
appreciate
really
that
do.
note.
Yeah.
I think we had a couple of related questions on kind of the right balance between innovation and regulation, and how do we kind of both balance that, but also kind of reconcile the difference in pace of these two. And you talked about it a little bit before, but I was wondering if you could expand on that discussion.
Yeah, and I also really want to get to this question by Yi Zhao, Zhu, because I about STS. I think that's really important too. So what I'll say briefly about that is I'm not anti-technology. Like I'm not like the Amish. I'm not assigning the Amish, way of life as a you know suggestion. Um, I benefit enormously from technology. We all do. And I do think that, one of the things I worry about happening in the United States is supposedly we're, trying to deregulate technology, which is not very regulated to begin with, in order to maintain our edge. But the absolute worst thing we can do is to defund basic research. I mean, the reason that the United States has had such an incredible technological advantage over other nations has been because first the defense industry, later on NSF and NIH and so on have invested massively in basic research. And we have invited people into the United States with expertise. I can't tell you how many of the teams at University of Washington have foreign members who are incredible and add enormous amounts of value. And so, by excluding the best, by excluding other minds from the United States and divesting in basic research, we are doing so much more harm to American innovation than we could possibly make up by tweaking the regulations a little bit to have a little less regulation or forestalling regulation. That makes absolutely no sense. So I think one of the things you have to remember is if you want to encourage rapid innovation, invest in people, recruit people, and yes, don't make it overly burdensome. Don't stifle innovation in some arbitrary way. But the pro-innovation policies that are going to drive American innovation have to do with immigration. They have to do with investing in basic research. And it's like nobody serious disagrees with that, by the way. Like, I mean, I know people say different things, but like that's not serious. Like we know why America has had its edge. We've invested heavily. Okay, so if you don't mind, can I answer the STS
Oh,
question?
yes, go ahead. Yep.
Yeah. So, because we're sort of limited time. You mentioned, this is the question. You mentioned that law and technology should not simply become a branch of STS, but also needs its own methodological foundation. What are the essential elements of that distinct methodology, and how can they be a guide to scholars who are new to the field? I love that question. It's like I planted that question, but I just think it's great. So, the thing about STS is that science and technology studies has spent decades of like unpacking the way that technology shapes society and the way that society shapes technology. And it is very resistant to those daunting and confusing aspects of technology. So the notion that technology is inevitable and non-contingent, they call technological determinism or technological autonomy. The idea that technology sneaks human will into objects. You find that in Langdon Winner. Do artifacts have politics? You find it in Bruno Latour's invocation of technology being society made durable. And then there's a whole super sophisticated apparatus like Scott, social construction of technology, that it just uses case studies as its primary method of delving into precisely this imbrication between technology and society. And all that is very helpful and wise and helps to avoid the problems. But there are two distinctions between STS as a field and law, which make them a little incompatible. One of them is that we are so comfortable with normativity. in the law for the reasons that I described. In the book, I do a full-throated defense of like why law interpretation, legal interpretation is inherently normative. I draw from Dworkin and Robin West and others. But we're very, very comfortable telling what you ought to do, what you should do. And there isn't that same instinct in STS because it's based in anthropology, sociology, history. And so there's a phobia on many in STS about telling you what you ought to do about a situation. We're just saying it's very complicated. We're not what to do about it. And so that there's increasing normativity in some critical traditions in STS, but I walk through that whole thing in a chapter on STS that's called The Scale and the Reactor. The second difference is that law as a discipline is what Julie Cohen calls relentlessly pragmatic. We grew up in the US in the pragmatic tradition. Oliver Wendell Holmes Jr., who was the sort of foreparent of legal realism that shaped the academy and the bar in the years since the turn of the century, he was like friends with Dewey and James, and he studied with Pierce and all the, I mean, if you ever have a chance to read the Metaphysical Club, it talks about the origins of American pragmatism. Point is, we're deeply, deeply pragmatic. We want to tell you, like what to do, but actually really, and talk about the levers of power and what you'd have to do pragmatically. That is not the same thing. I mean, one of the criticisms of STS that's been made internally and externally is that it just complexifies everything. There's always more to know. There's always another dimension. It's so complicated. It's so complicated. And what I like to say about STS is that it's beautiful music, but can you dance to it? In other words, what do you do practically about these problems that you have so thoroughly unpacked? And what I find in STS, and I feel like I'm pretty justified in saying this, I mean, maybe people can push back, that with some exceptions, STS, when it does bother to jump over and start to talk about what you ought to do, it becomes noticeably less sophisticated. So you'll have this hugely sophisticated analysis of something, and then there's the part where they're like, oh, what should I do about it? And they start to decide, oh, maybe we can be more normative and say what to do about it. And all of a sudden you get this sort of stock answer about like, people should participate earlier in the process of design. Okay? That's not what, that's not what law is going to do. Law is going to really be invested in the particulars of how do we engineer this change in our society in light of the real levers of power. So basically what I say is that every law and technology scholar, every person who touches technology ought to be aware of STS and know what STS has contributed, which is immensely important. But that if we became a branch of STS, or we simply wholesale imported STS into law and technology, we would miss out on the normativity and the pragmatism that characterizes law in general. And so I make that argument in the book. Yeah. Oh, it does look like so someone has put the book in the chat, and you can read the book online if you have access through university libraries. And incidentally, I have to jump off, obviously, but I am super easy to find. I'm on LinkedIn. You can email me. If you have follow-up points or questions, or I can just be of help to you, I'll just put my email in the chat. You can find me on LinkedIn. I'd love to hear back from you. I'd love to hear that you read the book and hated it or loved it or had questions, but I'd also just love to hear what you're working on, right? So this is me. Thanks for being such an important part of this whole community and ecosystem.
Thank you so much for being here with us today. I think we all appreciated your insights. So maybe let's just do one last round of applause.
Oh, okay.